Hi everyone, welcome back once again. And today we are going to talk about the position of chiefs, or what we usually know as Destoolment of chiefs. And before we proceed, I would like to say a big shout out to Maxwell Klujesin and Senyo Togbeche. They have been very interactive on my pages on YouTube or even on TikTok, and they've asked a lot of questions, especially Maxwell. And this is one of Maxwell's questions relating to Destoolment proceedings, so I'm going to deal with that today. So when we say Destoolment or deposition of chief, it's like, okay, they've given the stool to a chief, or they have installed him, as we talked about in our previous episode, and they are removing him from that office, so he ceases to be a chief. That's what we call deposition or Destoolment of a chief. And we might have all heard about this in olden days, that they'll remove someone's sandals or take his walking stick from him or his towel from him. Then the moment they remove your sandals, you cease to be a chief. But we all know that we have laws, and in the spirit of natural justice, hearing from the person, and to also avoid people being judges in their own courts, the law and the Chieftaincy Act 759 of 2008 also is enshrined in our constitution, and we have constitutional provisions for dealing with matters relating to Destoolment. So it's not the case that you just remove someone's sandals or a chief's sandals or take his walking stick from him, then you have destooled him. I know a lot of people thought that still exists. It might have existed in the olden days, but now you must go through a certain procedure or legal procedure in doing so. And I must also establish this very important caveat that we have categories of chiefs, and we have some chiefs whose tools are not consecrated. And despite the fact that I would also recommend the adherence to natural justice of hearing from these people, they do not fall under this category or this legal structure. Some of these may be Nkosyohini or tribal chiefs, Sarkin, Zongo, or maybe in an Akan institution, maybe the chief decided to have an Ewe person that he could liaise with to manage the Ewe community that is springing up or growing in his village or town. These are usually by appointments. Developmental chiefs, they are usually by appointment. The chief so which is based on his discretion to give you a position in his palace to help him manage certain aspects. Maybe he makes you the one in charge of his farm and gives you a stool with that. Many of such stools are not consecrated, they are not blackened. We do not call them real stools. And if it comes to even registration of chiefs, these chiefs are not registered within the chieftaincy institution. So these people may not have to pass through these same legal processes that I'm going to talk about, but if they fall short of the law, it's also prudent for the one who gave them the stool to hear their part first before making all his declarations and taking his position from them or removing them from office. All right, so we're going to talk, and we're going to focus more on section 40 of the Chieftaincy Act. And section 40 talks about the right to institute deposition or destoolment. So when it comes to subsection 1 of the Chieftaincy Act, it clearly states that it's only those who are clothed with the customary powers that can only institute destoolment proceedings or charges or deposition charges against any chief. And who are some of these people? We may usually term them in general terms as kingmakers. It's only the kingmakers, they are the ones who install the chief or put him on the stool. It's only these same kingmakers who can destool or institute destoolment charges against a chief. And every stool, every community, they determine who their kingmakers are. Maybe the Kronti Hini, the Jasi Hini, or some have, maybe with the Queen Mother, some have their own composition depending on their own structure or chieftaincy structure to determine who a kingmaker is. So it's only these kingmakers who must institute destoolment charges against this person. So if we have destoolment petition before any legal institution with that can determine chieftaincy matter, be it the traditional council, the regional house of chiefs, or the national house of chiefs, there must be at least one kingmaker among the petitioners before the issue could be heard, because they are the ones that are clothed with the customary powers to initiate or institute destoolment charges. Okay. And subsection 2 also talks about only when these charges are heard and considered by the judicial committee of the traditional council, it's only then that destoolment charges or the customary performance could proceed for the destoolment to take place. So this is just like a general preview of what I'll be delving into as to the procedure. Okay, so maybe I'll just give some hypothetical examples. Maybe in a particular town, the people are not satisfied with how the chief is conducting himself or how he's carrying out himself, and they wish to institute these destoolment charges. We have two main procedures. We still have the customary procedure, or we have the statutory procedure, which we usually see in our judicial committees. The customary procedure usually is that the oath of the paramountcy is invoked, what we usually call intam. So maybe you would invoke the oath of the paramount chief. And invocation of such oath is that you are drawing the attention of the paramount chief to something you are not happy with. So when they invoke that oath, the person who invokes the oath is arrested, customarily. And now when you are arrested, you are asked why you invoked the oath of the paramount chief, then you say your part. They can stand on this invocation of oath for the judicial committee to be constituted to hear this matter. This is one part. But the part which we usually handle, or the part that usually come before judicial committees, is filing of petition, as it is done in the high courts or in the district courts, magistrates, and the rest. Before the judicial committees of the traditional councils, the regional houses, and national house, petition is filed. And now I would also come back a little to let you know which kind of chiefs must be sent to which kind of judicial committee. So we have categories of chiefs. When you look at the Chieftaincy Act, we have the Asantehene and Paramount chiefs as the first category. And then we come to the next category, which is divisional chiefs. Then we come to subdivisional chiefs. Then we come to Dikrofor. Then we come to other chiefs. So paramount chiefs cannot be tried in the traditional council because it will be against maybe natural justice. You cannot, he is the head of that traditional council. So for justice to be served, such a person must be sent to the regional house of chiefs. So the regional house of chiefs has original jurisdiction over matters that affect paramount chiefs. So maybe if we take a town, let's say I'll use Shai Osudoku, for instance, in Greater Accra. So the paramount chief of Shai Osudoku, or let's take maybe New Joabin in Koforidua, they have issues against it. So they have to take the case, the kingmakers must take the petition to the regional house of chiefs, Eastern Regional House of Chiefs in the case of Koforidua, or to the Greater Accra Regional House of Chiefs in the case of Shai Osudoku. But when it comes to all other chiefs lower than that of the paramount chiefs, they must start from the traditional council. So then the traditional council has committees working under them. One of such committees is the Judicial Committee of the Traditional Council.